call the third case on this morning's docket, case number 114796, State of Kansas v. Jason Heckmeister.
May I approach her?
You may.
May it please the court, good morning. I'm Joseph Dash and I represent the appellant Jason Heckmeister. As a matter of introduction, I'm going to read this, so I beg your indulgence. As a matter of introduction, this case is before this honorable court due to a first-degree murder conviction, so a direct appeal to this court. I will say, unfortunately, my client's immaturity and outrageous behavior after his mother's death made this a sensational and theatrical trial. Getting to the background, in 2011, in September of 2011, Sheila Heckmeister was found dead in her house, which she shared with Mr. Heckmeister. Mr. Heckmeister was son of approximately 37 years old. A little bit of an unusual situation there to begin with. He found her about 4 o'clock in the afternoon. I don't recall what day of the week it was, but after he'd been running some errands. Shortly after that, well, he called the 911 and the police shortly thereafter appeared and pretty much removed him from the residence or kept him from going into the residence. Now, I'm not trying to get too deep into the facts here because I think you've all read the briefs, but what I'm trying to do is set the background for the audience, I suppose. Within that investigation, they took him to the police station and let him talk to his family members, and that was being recorded. They interviewed him a couple of different times, probably 3 or 4 times actually, within that first day. But he wasn't there until later after well, he found the body, I guess I should say. Long and short of it is, throughout the investigation of the crime, he did some unusual things. He made some statements to some exotic dancers, I think during the trial they were called strippers, that were certainly inculpatory. And then later after his, well, also during the investigation, he allegedly wrote some letters which implicated him as well, well, which attempted to throw the police off of his particular direction. There were some other different ancillary reasons for that, or at least put forth by the state. But we can all agree that Mr. Heckmeister was an unusual person and perhaps even childlike, but the big question is whether the state's unfair trial tactics resulted in a guilty verdict from the jury. I'm going to go ahead and move forward, and I forgot to ask for 2 minutes. Is it too late?
No, 2 minutes is granted.
Thank you.
When you're going through your the facts and your argument, you indicated he made some comments to what the state referred to as strippers.
Yes, Your Honor.
According to the record, he in fact confessed to killing his mother, to at least one of them, did he not?
Well, they were statements made that can be construed as a confession. That's correct, Your Honor. I wouldn't necessarily, they could also have been boastful. They could have been a childlike response to his mother's murder. They could have just been, I want attention, which I'll get to in a little bit.
The same with his tattoo.
Your Honor, yes, exactly. I understand, Your Honor. He's a very unusual person. He did some very unusual things, which did not help him at all at trial. I'll just put it that way. In the time allotted here, I can't possibly cover everything that happened in an 11-day trial. So what I'm going to try to do is focus what I think is most important. And I'm sure I'll be stopped very quickly. I wanted to focus on prosecutorial error, in that the majority of the briefing is, well, not the majority, a good half of the briefing is dedicated to that. In that the prosecutor, Mr. Hyatt, who is a respected colleague of mine, made a lot of misstatements of the evidence, specifically with respect to the time of death. And the time of death is very important because Mr. Heckmeister had alibi evidence from approximately 11:30 until the time he arrived back at the residence. The time of death in this case could not be established by medical evidence. It could not be established by the coroner. And in fact, the evidence was, you can't tell when she died. Well, unfortunately, what happened was the prosecutor in the case decided to take it upon himself to establish the time of death. And he did so almost as an expert and almost as a testifying expert, saying, well, this is how I see this. This is what, since I believe rigor mortis was set in when she was discovered, then she must have been murdered more than 4 hours before she was found.
Wasn't there evidence that came out that would support that claim?
There was evidence that would support a claim that she was stiff when she was found, but the only actual medical evidence was that the coroner said it could be a number of hours, some hours. There was no actual diagnosis. There was just Mr. Hyatt's decision to say that's when rigor mortis set in because that's what I believe based on my own experience.
Well, that's not what he said. Is it?
Not exactly, no. He said, I'm sorry.
I mean, you're arguing that his actual words, which I think I have them here, I think we know full rigor mortis was set in by the time she was found at 4 o'clock.
That is what he said, yes.
Why is that not a fair inference to be drawn from the testimony that referenced her actual condition at 4 o'clock?
Because the medical testimony was, I don't know when.
I understand, but set aside the medical testimony and I'm just asking why that isn't a fair inference to be drawn from the...
Well, because that's a scientific diagnosis. And I don't believe that he's qualified to make a scientific diagnosis.
So if he had just used the language from the witnesses that talked about, quote, stiff and cold, very rigid, no flexibility, felt like a rock, that you would not be objecting to that. It's because the use of the scientific term rigor mortis.
Yes.
Right?
Yes.
Okay.
Yes. And I believe that the problem with that is even if she's cold, rigid, and what have you, when the coroner says, I can't tell you when it set in, he's the expert. And Mr. Hyatt couldn't be the expert. And I think that's an unfair, he's usurping the role of the jury to find when this actually happened. So now, in addition to that, well, let's just go back with that. There's also some evidence there and that was, well, the dog was let out at 9 o'clock. And the dog was let back in somewhere around 1. And he attributed the letting of the dog out with the time of the murder, which he also, he piggybacked that in by saying, or bootstrapped that in by saying, well, we know that she was cold at this time, so we know she must have been murdered at least 3 or 4 hours, or 4 hours before she was found, at least, or more. So he speculated for the jury instead of letting them make that decision. And so in tying this Harley the dog argument in, what he did was basically said, we know she died during this time because the dog was let out. Well, that's not necessarily true. The dog was let out by someone, apparently at 9, and apparently let them in somewhere between 12:30 and 1 when Mr. Heckmeister wasn't there. At least the evidence would have shown that he wasn't there. So with that being said, I believe that the inferences, it's one thing to make inferences, but it's a different thing to state facts that the jury is supposed to be finding. So that being said, I think it's pretty fair to say, well, I don't know if I'd say it's fair to say. I would say that Mr. Hyatt absolutely took the role of an expert and testified and was unchecked in his testimony at closing arguments. So
you say that he was expressing a fact. In fact, in his argument, didn't he say, and I think I'm quoting it correctly, that it's likely that the mother was killed in the morning and the body was allowed to sit there?
that's correct.
Isn't that a comment on the inferences you can draw on the evidence and not him just simply saying there's proof. That's, in my view, the evidence establishes this.
I believe later on, he's more emphatic in his statements that is more direct. We know that she had rigor mortis. We know this. We know that, as if it's proven fact rather than, no. Granted, what you're saying, I do agree that he did say at one point, or he did argue at one point that it's likely, but it's only likely because of his prior assumptions he'd made, rather than what the medical evidence said, what the coroner said, who was the only one that was qualified to make that determination.
Well, there was more than medical evidence.
Sure.
There was all kinds of evidence of what happened in the morning hours after the dog was let out.
That's correct, yes, Judge.
The appointment with the therapist that she missed, based on her sending a text message, which she normally never sent, "Sorry, I don't feel well," sending that message at the very moment that it was later found that the cell phone was in a field out by Wanamaker. Isn't that right?
Yes, yes, sir.
So there's lots of other evidence
There was
that supports the morning time frame for the killing. Right?
there was a lot of circumstantial evidence. That is correct. I couldn't argue with that whatsoever. But it is the fact that we started off with we know when she was cold when she was found, and then that got extrapolated to the rigor mortis, which was not found by the coroner. Like I said, there's only one expert in this case. Well, there's several experts, but one expert dealing with the time of death, which wasn't established, the rigor mortis, which wasn't actually established. But the testimony itself, and I'll submit to you, if you read the coroner's testimony and compare it to Mr. Hyatt's arguments, which I would say were testimony, they're completely different. They're completely different. Now, inferences are fine, but at what point do the inferences become statements of fact? How far can a prosecutor go is the real question. How far can they make extrapolations on this evidence when the primary premise is not based on the evidence? If the primary premise is rigor mortis set in, death must have been before that, obviously it must have been before that, but it must have been several hours before that. So that's the primary premise is based not on evidence. That's my problem, and that's what the problem with this whole case is well, not the whole problem, there's lots of problems, but the problem with establishing a time of death, which couldn't be done by the witnesses. So why are we allowing the prosecutor to establish a time of death? That's the real question. Now, I'll move on because I think I'm getting too mired in that. There's a couple other things that were problematic, at least many things. But another problematic thing was another misstatement of the coroner's testimony, which was absolutely inflamed the passion of the jury regarding the indignities of autopsy. Now, I've already briefed this, and it's pretty clear in the briefing that the testimony of the coroner was different from what the prosecutor stated, and he stated them as fact when they are actually inferences he's making from an extrapolation of the coroner's testimony. So anyway, my time is up, and I haven't gotten nearly through this, but I'm not going to waste your time. Are there questions?
Counsel, can I just real quickly move you to the 6455 claims?
Yes.
And I just want to pin down where you're coming from. My understanding from the briefing is that you are not contesting the admissibility of the evidence on any grounds other than that its prejudicial effect outweighed its probative value. Is that correct?
Not exactly. The problem was that the judge was sold a bill of goods at the pretrial hearing, that this testimony was going to be used for this purpose. This evidence was going to be used for just this purpose. And it turned out that that evidence was being used for a number of items, not just, well, for example, let's take the quote-unquote missing wedding ring. Well, there was a hearsay statement made by the victim, apparently, that she was going to confront Mr. Hackmeister about a missing wedding ring, or believed there was a missing wedding ring. That was supposed to be used to show that there was a confrontation between Sheila and Jason the night before or shortly before the murder occurred. Well, it became a motif in trial, and I'll get to, I have a note on that, actually, I can go to that. It was a motif, but it was really no more than innuendo, and not evidence of a confrontation. It was just evidence that, well, the argued purpose was to show an alleged confrontation. And
But you
hence motive.
didn't object to that, and
What's
it came in to show that, right?
It came in
That's
to
not
show
your-
that,
your-
and many other things.
And the only argument you make to us is that it was more prejudicial than probative.
Well, I
right?
make that argument, but I also make the argument that it was not its intended purpose when he used it further, that it was not a burglary, that it was never found, that Jason uses the missing wedding ring to throw off the investigation, and that the wedding ring was the only jewelry missing.
Was there ever any preservation of that argument that the use of the evidence exceeded the scope for which its admission was granted?
I don't believe so beyond
I'm
the
just trying to
initial- I
drill
think-
down to what mistake do you think the district court judge made here?
Well, I don't think the district court is as nearly as culpable as the prosecution is.
This is an evidentiary claim. You're pointing to an error of the district court. We're not
That-
talking about prosecutorial error at that point, right?
Well, yes, you're
So
you're
what
correct.
was the error the district court judge made?
Well, it is an argument that it's more prejudicial than it was probative.
And that's really all. we
That's
have.
really all I can use.
Okay.
It's true.
And you concede that we review that for an abuse of discretion?
Absolutely.
Okay.
Any further questions? Thank you, counsel.
Thank you.
Good morning, may it please the court. The state appears by Assistant Solicitor General Jody Litvin. I'll go ahead and pick up with the 455 issue. The state agrees that, based on the briefing here, the defendant has waived the first two prongs of that analysis. Our position is that the use of the evidence doesn't really go to probative or the relevance, and that's not disputed here, that it was relevant or that it was material, and that those were issues in dispute. So we would argue that those first two prongs are waived, and really the focus is probative value versus prejudicial, undue prejudice. Another thing I'd like to note, just for the prejudice factor, we believe that this is highly relevant evidence and probative evidence, both pieces, and specifically as to the wedding ring, I think it states Exhibit 108, but I could be incorrect, but there is an interview with Detective Dickey where the defendant gets to explain that there was that confrontation with the missing wedding ring. So he explains not only that happened, there was no objection to that interview, there was no objection to that evidence coming in through that interview, and he gets to explain that that wasn't his motive. He explained that he didn't take the wedding ring, that confrontation happened, she misplaces things all the time, she probably misplaced it, and that certainly wouldn't be a reason for him, I think, what he says is to off his mother based on a missing wedding ring. So to the extent that was not probative or not as probative as the court believed, he got to explain that motive, and he got to put that in front of the jury that, hey, I didn't steal my mother's wedding ring, and I certainly didn't kill her because she claimed or alleged that I stole the wedding ring. So we don't believe it's unduly prejudicial, considering that he got to explain that to the jury and that came in unobjected to. I'll hit with the time of death and rigor mortis. I'll move to those prosecutorial error issues. Our position is that the prosecutor did not misstate facts or state facts that were not in the evidence. I think it's important to look at these things together. The evidence regarding rigor mortis comes in as the court has noted through Corporal Green's testimony that her body was rigid and very cold at the time he arrived at the scene. There was no flexibility or pliability in her skin, which he also indicated that her arms were up around her neck. And I know that she had been flipped over, but her arms were up stiff around her neck. The reasonable inference is that if she was stiff, she was not flexible, indicating that her body was in full rigor. And then we can turn to Dr. Mitchell's testimony, where he indicates her arms were up around her neck at the time of the autopsy. And in order to examine the body, he has to break rigor, so he straightens out the joints that are frozen. Again, if she appeared stiff by Corporal Green's testimony, her joints I mean, there's a reasonable inference that her joints were frozen, and he has a detailed explanation about what rigor mortis is, and talks about it not happening instantaneously except for exceptional circumstances which weren't present in this case. Could not tell the exact time that rigor set in, but that's not important here, given that the two pieces of evidence, Corporal Green's testimony and what he's talking about as to how rigor sets in, we believe that those were reasonable inferences from the evidence presented. He certainly didn't say, since I believe she was set in full rigor, we believe his comment that we know that she was in full rigor was based on those two pieces of evidence. And also, importantly, Dr. Mitchell says that she had been dead for at least some hours. Taking that in conjunction with the argument about Harley the dog and when he was out, the time of death and the prosecutor's statement that it was likely done in the morning was, again, a reasonable inference on the evidence presented, tied directly to it. There was a neighbor's testimony that said the dog was out between 9 and 9:30 a.m. and 12 and 12:30 p.m. The defendant was home until, at least he says, 11 or 11:30 p.m. So that's highly unusual for the dog, which is an indoor dog, to be out for those hours barking when neighbors testified that normally the dog was let out for a short period of time and could come back in. And even if
what
we
about
take
the description of the strangulation and that the victim could breathe just fine? Isn't that a stretch?
the state's position, judges, or Your Honor, is that this is a comment on the strangulation, the type of strangulation that was had, and the difference between the blood going into the brain and not being let out, as opposed to it being totally shut off, her airway being totally shut off. So no, I don't believe that's a stretch. I
She
think.
could breathe just fine.
Well,
I mean, I'm not
Sure.
sure it makes a whole lot of difference, but it seems to me that that's almost putting him at the scene and describing what occurred.
I would disagree, Your Honor. I think that it's the focus of those comments were to point the jury toward the premeditation here. And in describing the different kind of strangulation that occurred, it wasn't where her trachea was crushed, so she could breathe. It was where the blood was not flowing out of her brain, and it built up in her brain. So I think that those comments were not made to inflame the jury, but to specifically point them to, here's how you can get to first-degree murder, here's how you can get to premeditation.
Let's say we assume for the purposes of my question that we find that that was not a fair comment on the evidence.
Okay.
Just real quickly answer the harmlessness question on that.
I will do it as best I can quickly, because that'll cause, I'm going to go through all of the circumstantial evidence that was presented here in the most efficient way I can. First, I would point the court to the crime scene and the scene at the house. No signs of forced entry or home invasion. Things are still neat and orderly. The crime scene, the actual place where she was stabbed and strangled, was a very small section of the house. The house isn't ransacked, nothing out of place. She was killed upstairs, and then the items that were stolen from the basement. They were items that had specific value to the defendant. They were items that were in the lockbox with the $6,000 inside a dresser drawer. And again, a very specific location, and nothing in the basement was out of place. There was no evidence of a burglary down there. There were computers and other valuables, TVs that were not taken from upstairs, other jewelry that wasn't taken. The computer tower that was taken was neatly unplugged. Again, it wasn't yanked out of the wall. And there was nothing else missing from upstairs. Evidence of a staged crime scene. There were the 3 perfect bloody footprints that were kind of there by the door. We had the expert who came in who talked about that was too many footprints perfectly spaced, and too many for the spacing for that 18 inches. So that was evidence of a staged crime scene. There were no other footprints. There was no blood on the front porch or on the linoleum or out the front door, indicating that someone may have gone through the front door other than those 3 bloody footprints. Sheila's blood was found on the back glass sliding door. Her blood was found in the hall bathroom and on the towel and on the sink, indicating that somebody cleaned up following the murder. And again, that evidence of the blood on the back sliding door could be used to infer that the killer was letting the dog back in, putting the dog in the kennel where he was found at 4 o'clock. There was also dilute blood stains underneath the defendant's desk in the basement where his computer tower was neatly unplugged and stolen. Next, we can go to his odd behavior and injuries. There's a conversation that the defendant has in the room, the soft interview room at the law enforcement center, with his concerns after the murder. He kept repeating where he was. He knew exactly where he was that day. He could account for all of the places he went, the specific times. He had receipts. He was wearing a bright orange sweatshirt. Or polo. He was talking about how, well, of course they have video. They can see me. They can account for where I was going. Very concerned about where he was during that afternoon. And it's not normal for him to keep receipts, as his father testified to. Importantly, in Detective Dickey's interview that he had with him later in October, he couldn't account for anything he did that Friday night before the murder. I don't know, I went to Starbucks. I was there for maybe an hour or two. I came back home. What time did your mother get home? I don't know, maybe 5:30. Sometimes she gets home early, sometimes she gets home late. Yet when we went to Saturday, the day of the murder, I went here, everything I did. So that was unusual. His injuries, he was concerned about injuries on his hands and legs, and he explained how he got those by working out with kettlebells. There were rug burns on his legs. His family members talked about how he was constantly covering up those rug burns on his legs. He had 2 different explanations for those. He fell down the stairs and then he fell up the stairs, breaking his glasses. As we mentioned, the evidence of the dog being outside, how a neighbor testified from 9 a.m. to 12 or 12:30, the dog was out barking, which was unusual. This would go in conjunction with the fact that there was no signs of forced entry or no one broke into the home. The dog had no blood on it. It was clean, indicating that Sheila was probably murdered while the dog was either outside or in the kennel. The cell phone data and the location of the cell phone, as we touched on, that she missed an appointment with her therapist at 11 a.m. And she had never missed an appointment in the however many years she had been going, 6 years of therapy. And she never contacted her doctor by text message, yet that day she did, and said, sorry, I don't feel well, at 11:42 a.m. And the evidence showed that 11:44 a.m. her cell phone was located.
Attention, attention, attention. An emergency has been reported. All occupants walk to the nearest exit and vacate building.
justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Thank you. Please be seated. Counsel, that may be a tough act to follow, but you're welcome to continue.
Thank you, Your Honor.
I think you're in the middle of reciting evidence as to why you believe this is harmless error.
Yes,
Okay.
I'll try to find where I was. I think I was talking about the cell phone data, and just to restate, I'm Jody Litfin, Assistant Solicitor General on behalf of the state. So her text message that she sent from her phone saying, "Sorry, I don't feel well," at 11:42 a.m., the state presented cell phone data that indicated that 11:44 a.m. her cell phone was located in an open field along Wanamaker Road, so not in the house. Next, the defendant's whereabouts the day of the murder. There were a couple of points of evidence here that were odd. The Starbucks visit around noon. The defendant was a regular at Starbucks. He always ordered an Americano. Joe Patton came in and testified how that day he ordered something different, a different drink, and he asked how his day was going, and his defendant responded that his mother had died. And that would have been curious because that was before 4:00 p.m. when he found his mother murdered inside the house. He also visited the assisted living facility where his grandfather was, and the nurse testified that he only spent 15 minutes there on the day of the murder. He looked like he had not been to bed yet. He looked really worn out when normally he visited his grandfather for an hour or 2 hours and ate lunch with him. There was also DNA consistent with the defendant's found on the twine around Sheila's neck, which is important because he repeatedly stated that he didn't touch the twine. In his interviews, he stated that he used the medical scissors to loosen the rope and that he never touched the twine, and that was a point of contention that he kept saying, "I didn't touch the twine, I didn't touch the rope. I used those scissors to get in there and loosen the rope." The Crime Stoppers tip on November 10th, where the defendant's brother, the Crime Stoppers tip, the timeline here is November 10th, the defendant's brother tells him that he has to move out by the 31st, and that the insurance is putting a hold on the money because he is not cleared as a suspect yet, the defendant. And on November 14th, Crime Stoppers, so 4 days later, gets an anonymous tip specifically saying that 2 people were involved from Kansas City in the murder and that her sons were not suspects. Next, the evidence that he bragged to some dancers and a stranger about the murder, and really the most important piece of evidence here is what he said to Catherine Shaw, and she was the manager at one of the gentlemen's clubs, and there was the conversation where he said, "My mother's passed away, they think I may have killed my mother," which morphed into, "I did kill my mother," and he wasn't really worked up or upset about it. They talked about his tattoo and why he would get the memorial tattoo, and he said to give the jury sympathy. And then he reached out and grabbed Shaw's arm and said, "I really did kill my mom." Shaw responded sarcastically, "If she hears many stories, well, good for you." And he grabbed her again and said, "No, I really did. I hacked that fucking bitch up." And he told her that he bled all over the carpets, that he wanted to live in the house, but he had to replace the carpet and the drapes, and he seemed upset about that. And then he again stated that same comment that he hacked her up. And he said it with a sense of desperation, according to Shaw, that he really wanted to be believed and like he had put in all of this effort to do it and wanted her to believe him. Egypt Gaston also came in talking about how he was bringing up his mother during the lap dance, how that was odd, told her about the tattoo, was talking about how law enforcement thought he killed her, but he never seemed to be upset about it. He said, "What's it like talking to a serial killer?" And then he said, "No, just kidding." Jared Harson also talked to him about the murder, or the defendant also talked to Jared Harson about the murder, told him imagine being a suspect, talked about how TPD was out to get him, and told him about the note in the top of the dresser drawer. He never told Harson that he killed her, but he repeatedly said that he could not have done it. And then we get to the letters, which start out by describing the murder, how it was done, how they got in the house without being detected, the fact that he pulled it, I think it was a candlestick or some sort of object to beat her until she was down. And then when that wasn't enough, he grabbed the rope out of his clipboard, he said, and strangled her to death. So there's 17 anonymous letters. The one that's important is the one that he sends to Brandon Wallace, where there's another letter inside of that, addressed to S. Wright, I believe. And that's how we know that once he is arrested, the letters are coming from the Shawnee County Jail, and Brandon Wallace takes that letter back to the law enforcement, where they start to track these letters then and can see them coming out of the jail. And in the letter to S. Wright, that's where he comes up with more details about the murder. And the letters just keep getting more detailed and providing explanations for things that only the murderer would know. And one of those letters takes credit for the first letters, the first couple of letters, so we know they're all tied back to one another throughout that timeline of the 17 letters. And then he also did have a financial motive to kill his mother. She was going to kick him out. There was evidence of that they were going to have a discussion about him moving out of the house, the confrontation about the missing wedding ring, the fact that he was unemployed and didn't have a steady source of income, and he didn't want to move out. He had it pretty much made in the basement there, so there was a financial motive for that as well. And then I think the only other thing for harmlessness I have that I briefed was looking at the instructions that were given here. The jury was properly instructed in instruction number 1 that statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements are made that are not supported by the evidence, they should be disregarded. So we should presume that the jury followed the instructions given, which properly told them to disregard anything that wasn't supported by the evidence. And in reading the prosecutor's closing, he did hit on the state's burden of proof properly. He did talk about everything was couched within the evidence that was presented, and he did talk about how we're here to talk about the evidence, we're here for you guys to decide what the facts are and apply the law. So overall, I think that was an appropriate legal argument to make if this court finds that any one of those comments were improper. And I don't believe I have anything else for harmlessness.
Any more questions? Thank you, counsel.
Thank you.
You may.
I've been told that I need to announce my name again. My name is Joseph Dash, and I represent the Mr. Hackmeister, the appellant. Now, what my colleague has brought up in one instance is completely incorrect. There was a 4-page argument in the middle of trial about whether the missing wedding ring evidence should come in even through Mr. Dickey, or Detective Dickey. So there were pretrial arguments as well, but there was also an argument right in the middle of trial that said we shouldn't have this stuff in. So there was an argument, there was an objection. It was 4 pages long, and there was an objection right prior to Dickey's testimony. I just want to make that clear. Now, I'm not going to climb Mount Everest to try to explain everything that my client did, which Ms. Litvin brought up as far as circumstantial evidence, because I don't have the time. That's not even possible. But what I will say is, one thing that Justice Rosen brought up was there was a lot of first-person statements in Mr. Hyatt's final argument. In fact, there was a whole dissertation on what Mr. Hackmeister did as if Mr. Hyatt was there at the time, and all of the events that he believed happened, he laid that all out as if he was there. I think that is a problematic thing. Was this behavior odd? Absolutely. Absolutely. But I guess I have to ask the quintessential question. If the phone was being used at 11:42 and 11:44 and it was out in the field on Monument, who let the dog in? Who let the dog in between 12 and 1 o'clock? Certainly wasn't Mr. Hackmeister if we're claiming that he was out there in the field with the mom's phone. And certainly it wasn't him if he's out there shopping on Moneymaker. So somebody had to let that dog in and put it into that kennel. At the time, at least is what the evidence established. When was that dog let in? It was after 12 and he wasn't there. So I'm just pointing that out because that was part of Mr. Hyatt's theory that established the time of death, which I think is problematic and I just think that's a little bit problematic. Is there any questions? Or
I'd like to go back to your very opening statement where I ask about his statements to either the bartender at the club or the dancers. And you seem to say something like, well, he made all kinds of statements or he exhibited some unique behavior. And you've heard opposing counsel go through, from what I understand, his exact words according to Catherine Shaw. I'm just kind of curious if you could respond to that particular piece of evidence. Are you saying that it did not happen? Shaw was not believable, or I'm just kind of curious. It seems to be sitting out there in the middle of the room, and you haven't talked about it.
Well, Your Honor, there's nothing I can really say about it other than it was certainly a boastful statement. It was certainly a statement that he made. But then again, we talk about, and I'll make a metaphor. How many people have confessed to being the Zodiac killer that really weren't? How many people confessed to a crime that did not do it? How many people made boastful statements because they wanted to be heard or wanted to feel important when they're really not? So, and that's a rhetorical question, and I apologize, I can't really answer your actual question. But I don't disagree that happened. I don't disagree that testimony occurred, but it could have just been boastful speaking as well. And that's what I have to write it up to, because I can't explain it any other way.
I understand. Any more questions? All right, thank you, counsel.
Thank you, Your Honor.
Thank you both
Thank
for
you.
your arguments this morning. Court will take this matter under advisement.